Welcome. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. First Amendment, U.S. Constitution. Prior restraint isn't just about stopping you from speaking or writing. It can apply to many of our fundamental rights, including the right to travel. Just as the government cannot prevent you from publishing a newspaper article before you've written it, they also should not be able to stop you from traveling behind the wheel of an automobile before you've even started your trip. This restriction should only apply if there's a clear and specific reason to believe you might cause harm, rather than a general and vague concern that applies to everyone in every situation. This broad brush approach to restricting rights goes against the principle that our freedoms should be protected unless there's a specific demonstrable reason to limit them. It's not about public safety at this point, it's about control. The government shouldn't assume everyone is a potential threat just because they want to exercise their right to travel behind the wheel of an automobile. Our system should trust citizens to use their rights responsibly, intervening only when there's clear evidence of wrongdoing or danger, not preemptively restricting everyone's freedom just in case. But in the context of mandatory registration, plates, and licenses, the concept of prior restraint becomes even more complex and controversial. These requirements, ostensibly implemented for public safety and administrative purposes, can be seen as systemic prior restraints on the right to travel by mandating that individuals obtain government permission in the form of registration plates and licenses before they can legally operate a vehicle on the roads. The state is effectively imposing a blanket restriction on travel that applies to everyone regardless of their actual driving behavior or their intent. The system creates a situation where the default position is that travel by personal vehicle is prohibited unless explicitly permitted by the government. Such a framework inverts the traditional understanding of rights, where freedoms are presumed to exist unless specifically restricted for compelling reasons. Instead, it establishes a paradigm where the exercise of the right to travel is contingent upon government approval, transforming a fundamental right into a privilege granted by the state. Critics argue that this approach goes beyond reasonable regulation and ventures into the territory of prior restraint, as it preemptively restricts the right to travel before any actual infraction or harm has occurred. Supporters, however, contend that these measures are necessary for public safety and orderly transportation systems. You guys, I want to touch on a more nuanced area of this discussion that relates to agency discretion when accepting applications for driver's licenses. If an agency like a Department of Motor Vehicles uses their discretion to deny your driver's license, and that discretion isn't aligned with the authority granted to the agency by the state statutes, that is a situation of acting beyond the scope of their authority, and is part of this prior restraint of the right to travel argument that I'm raising. To give you some background, there is an important distinction between regulations and statutes in the legal system here in the U.S. Statutes and regulations are two distinct types of laws that work together in our legal system. Statutes are primarily laws enacted by legislative bodies like Congress or state legislators. On the other hand, regulations are rules issued by executive branch agencies to implement and enforce these statutes. They offer specific details on how to apply and enforce the broader statutory laws. The key differences between statutes and regulations lie in their origin, scope, and authority. Statutes come from legislatures and provide broad frameworks, while regulations come from executive agencies and fill in specific details. Importantly, agencies can only issue regulations that are authorized by statutes, and these regulations must align with and cannot exceed the authority granted by the statutes. This relationship is crucial when examining issues like driving regulations, where it's essential to consider both the underlying statutes and the more detailed regulations issued by agencies such as state departments of motor vehicles. Understanding this interplay helps us recognize potential overreach and protect our fundamental rights. State statutes and regulations can potentially create unconstitutional prior restraints on the fundamental right to travel behind the wheel of an automobile in several ways. Statutes might impose overly broad restrictions, discriminatory limitations, excessive licensing requirements, punitive measures, or overly restrictive residency requirements. For instance, a law requiring all citizens to obtain permission before leaving the state without a compelling state interest would likely be unconstitutional. Regulations, being more detailed and specific, can also infringe on the right to travel. They might grant excessive discretion to administrative officials, impose burdensome procedural requirements, use arbitrary or vague standards, require excessive data collection, implement disproportionate security measures, or create economic barriers. For example, regulations that impose complex, time-consuming, or expensive procedures as prerequisites for accessing rights. It's crucial to note that both statutes and regulations must be carefully crafted to avoid creating unconstitutional prior restraints. The key is ensuring that any restrictions are necessary, narrowly tailored, and serve a compelling government interest. My personal experience with the Illinois Secretary of State driver's license application illustrates how prior restraint can impact our right to travel. In Illinois, I encountered an unexpected issue related to signatures during my application process. The Illinois state statute defining signature does not prohibit the use of punctuation marks. Specifically, 810 ILCS 5/1-201B37. A signature is defined as any symbol, executed or adopted by a party with present intention to authenticate a writing. There doesn't appear to be a specific Illinois statute that explicitly grants the Secretary of State discretion to regulate the use of signatures. And there's no mention of any type of prohibition of punctuation marks within that statute. However, the Secretary of State's office has implemented a policy on the suggestion of their legal team, allowing them to deny a license application if the signature contains punctuation marks. Agencies do have some wiggle room in implementing laws, but they can't go beyond what the statutes allow, and this punctuation mark issue is a content-based restriction. Courts usually look at content-based restrictions with strict scrutiny, meaning the government needs a really, really good reason to restrict the right, essentially. By denying driver's licenses based on signature style, the agency is effectively implementing a licensing scheme that restricts personal expression preemptively, as well as places a prior restraint on the right to travel. This practice not only limits an individual's form of expression, but also imposes a prior restraint on the fundamental right to travel, because without the license, we're not supposed to get behind the wheel, correct? Finally, there's a chilling effect, First Amendment chilling effect. People might change how they sign just to avoid trouble or just so they can access their right. And that's a big no-no when it comes to freedom of expression, especially if the punctuation marks are made with clear intent to exercise a First Amendment right. The agency might argue that standardized signatures make processing easier, or that this falls under acceptable time, place, and manner restrictions. But on the flip side, this rule goes beyond what state law allows. It restricts content without clear authorization, and it seems pretty arbitrary. So, to sum it up, prior restraint encompasses more than just the suppression of speech. It extends to other fundamental rights, such as the right to travel. The government's ability to impose preemptive restrictions, whether through mandatory vehicle registration or agency discretion in issuing driver's licenses, poses a significant challenge to the presumption of freedom. By requiring government permission to use a car, the state essentially shifts the burden of proof from demonstrating imminent harm to preemptively limiting freedoms, which undermines the core principles that rights should be protected unless there is a compelling reason to restrict them. Thank you very much.